Welcome back to Big Law University. Today we're going to be covering civil procedure topics to prepare any law student for the bar exam or for just any law student who's taking civil procedure to understand the material a little bit more better. So we're going to go ahead and cover a couple of topics here. The first topic is going to be the role of a judge, jury, the burdens of proof, and jury trials in tort cases. Now, many students approach torts thinking the hardest part in memorizing the elements of negligence, intentional torts, or strict liability. But on the bar exam, many tort questions are testing something much deeper. They want to know whether you understand who decides what, who decides the law, who decides the facts, who decides whether a case even reaches trial, and who decides whether the evidence is strong enough for a party to win. Because in a courtroom, the judge and the jury have completely different jobs. The judge is not simply sitting there watching the trial happen. The jury is not simply deciding who they like better. Each has a specific role, and understanding that separation is essential for both tort questions and civil procedure questions on the bar exam. In this lesson, we're going to break down three major concepts. So first, the roles of the judge and jury in tort cases. Second, the different standards courts use when deciding whether a case should be continued or be dismissed. And finally, jury trial rights, jury selection, jury demands, jury size, and objections to jury instructions. So, number one, roles of judge and juries in tort cases. Let's begin with the person who controls the courtroom, the judge. In a tort case, the judge wears many different hats. However, for exam purposes, the two most important roles of the judge are, first, the judge presides over the trial. Second, the judge serves as the finder of law. Now, you might be asking, Mr. Big, what does that mean? And I will tell you exactly what that means. It means the judge decides legal questions. The judge determines what legal rules apply. The judge decides dispositive motions. The judge determines whether enough evidence exists for a factual issue to even be presented to the jury. The judge decides what evidence the jury is allowed to hear. The judge instructs the jury on the applicable law. And if there is no jury, the judge also becomes the finder of fact. In a bench trial, the judge takes on both responsibilities. The judge decides what the law requires, and the judge decides what actually happened. Now, compare that to the jury. If there is a jury, the jury becomes the finder of fact. This is one of the most important distinctions to remember. The jury does not decide legal questions. The jury does not decide what the law means. Instead, the jury listens to admissible evidence and decides disputed factual issues. For example, did the defendant act negligently? Did the defendant did the defendant's conduct actually cause the plaintiff's injury? Was the plaintiff injured? Did the evidence prove liability under the required standard of proof? Those are factual questions. Those belong to the jury. A simple way to remember this distinction: the judge decides the rules. The jury decides what happened. The judge tells the jury, this is the law you must apply. The jury then answers, based on the evidence presented, this is what we believed happened. The jury also plays an important role when multiple parties may share responsibility. For example, imagine a car accident where the defendant was speeding, the plaintiff was distracted while driving, and another person created a dangerous road condition. The jury may be responsible for deciding how responsibility should be divided among multiple parties if the jurisdiction uses fault-based apportionment. The jury is not simply deciding who wins. The jury may also determine how much responsibility does each person have. Part 2, standards for granting dispositive motions. Now, here is where many students get confused. A tort lawsuit does not automatically make it to trial. Before a jury hears evidence, a party may ask the court, should this case continue? These requests are called dispositive motions because they can dispose of the entire case. In other words, they can end the lawsuit before trial. For tort questions on the bar exam, there are 3 dispositive motions you are most likely to see, and they are a motion to dismiss for failure to state a claim, a motion for summary judgment, and a motion for judgment as a matter of law, also called JMOL. Each motion happens at a different stage of litigation and asks a different question. Understanding the difference between them is critical. Now, part 3, motion to dismiss for failure to state a claim. The first motion is the motion to dismiss for failure to state a claim. This motion usually happens early in the case. Typically, the defendant files it after the plaintiff files a complaint, but before discovery begins. If the motion is filed after the close of pleadings, it is called a motion for judgment on the pleadings. Regardless of the name, the judge, not the jury, decides whether the motion should be granted. This motion is sometimes called the so what motion. Why? Because the defendant is essentially pointing at the plaintiff's complaint and saying, so what? The defendant is arguing, even if everything the plaintiff wrote is true, the plaintiff still has no legal claim. The standard asks whether the plaintiff would be entitled to recover, assuming she can prove every factual allegation contained in her complaint. However, the court ignores formulaic legal conclusions and unsupported statements of law. For example, if a plaintiff cannot simply write, the defendant, he committed battery against me, that is only a legal conclusion. The complaint must provide facts supporting the elements. The plaintiff will need to allege facts such as the defendant intentionally touched the plaintiff without consent and that contact was harmful or offensive. Those are factual allegations. So the question becomes, if all factual allegations are accepted as true, would the plaintiff legally win? If yes, the motion should be denied. The case continues. But if the alleged facts, even if proven, would not establish every element of the plaintiff's claim, then the motion should be granted. The case ends. Part 4, motion for summary judgment. The next motion happens later. A motion for summary judgment is usually filed after discovery closes, but before trial begins. Unlike a motion to dismiss, the court is no longer looking only at the complaint. Now the court examines evidence. This includes things like depositions, documents, affidavits, and other evidence available to the court. Summary judgment is sometimes called the put up or shut up motion. Why? Because at this stage, the plaintiff and defendant must show what evidence they actually have. The question is no longer assume everything is true. Instead, the question becomes, is there enough evidence for a reasonable fact finder to decide in favor of the non-moving party? A court should grant summary judgment if no reasonable fact finder could find for the non-moving party. If a reasonable fact finder could find for the non-moving party, summary judgment must be denied. This means the court is asking whether there is a genuine issue of material fact. A material fact is a fact that could affect the outcome of the case. Now, this is a very important point, so listen to Mr. Big. A motion for summary judgment does not ask whether the non-moving party will ultimately win. The judge is not deciding the final result. The judge is only deciding whether the evidence is strong enough that the case deserves to go to trial. The judge is asking, is there a real factual dispute here that a jury needs to resolve? Defendants usually file summary judgment motions more often than plaintiffs. These motions are commonly granted when, based on the evidence available, no reasonable jury could find that every element of the plaintiff's claim has been satisfied. Now, part 5. Motion for judgment as a matter of law. The final major dispositive motion is the judgment as a matter of law. Again, also called a JMOL. This motion occurs during trial. Usually it is made after the close of evidence or after one party has finished presenting its evidence. The motion must generally be made before the case goes to the jury. However, if it is made before the jury receives the case, it may be renewed after the jury returns a verdict. The standard is similar to summary judgment. The court asks, based on the evidence presented at trial, could any reasonable fact finder rule for the non-moving party? If no reasonable fact finder could do so, then the court should grant JMOL. For example, if the plaintiff has the burden of proving negligence, but after all evidence is presented, there is no reasonable way a jury could find duty, breach, causation, and damages, those are the elements for proving negligence, the defendant may win through JMOL. On the other hand, if the evidence shows that no reasonable jury could find anything except that the defendant is liable, the plaintiff may win through JMOL. If the motion is renewed after the jury's verdict, the standard becomes even more demanding. The court will usually grant the motion only if the jury's verdict was so unreasonable that it goes against the overwhelming weight of the evidence. The verdict must be so unsupportive that it appears to have been based on something improper, such as bias. Part 6, Jury Trials and the Seventh Amendment. Now, let's move into jury trials. Here is a question that appears simple but tests several important concepts. A student takes a scenic selfie in a national park. She falls from a cliff and suffers injuries. She believes the fall occurred because a federal contractor installed a defective handrail. She sues the contractor for $500,000 in damages and also requests an injunction preventing the contractor from using similar construction methods in the future. The federal statute allows the lawsuit. The federal statute allowing the lawsuit says nothing about whether the plaintiff receives a jury trial. Now, the question Mr. Big has for you is, does she have the right to a jury? Now, Mr. Big's going to give you the answer. The Seventh Amendment provides the right to a jury trial in common law cases when the amount in controversy exceeds $20. A jury right can also come from a statute. Federal Rule of Civil Procedure 38 preserves both constitutional and statutory rights to a jury trial. However, the jury right does not apply equally to every type of claim. Generally, jury trials apply to legal issues, but not equitable issues. Claims for money damages are generally considered legal. Claims requesting injunctions or other non-monetary remedies are generally considered equitable. If a case contains both legal and equitable issues, the court must first try the legal issues before the jury. After the jury decides those issues, the judge handles the equitable issues. The judge must follow the jury's factual findings. Here, the student's claim for money damages resembles a traditional tort claim. Therefore, she has a right to a jury trial on that issue. However, the request for an injunction is equitable. That issue does not receive a jury. Therefore, the damages claim goes first to the jury, and the judge later decides the injunction issue based on the jury's factual finding. Part 7, jury demands. Now, imagine the student's complaint does not request a jury trial. The contractor responds by filing a motion to dismiss for lack of personal jurisdiction. Before the court rules on the motion, and 3 weeks after filing the complaint, the student files a written demand for a jury trial. Is that demand timely? Under Rule 38, a party must demand a jury trial within 14 days after service of the last pleading directed to the issue. Now, here is the key word Mr. Big is going to give you. The key word is last. Not the most recent document filed, the last allowable pleading. A jury demand may be included in a pleading or filed separately. The court must honor a proper jury demand. If a party fails to demand a jury trial, the court may proceed without one. However, the court may still order a jury trial if a party moves for one and the failure was proper to correct. Here, the contractor had not filed an answer yet. The answer is generally the final pleading directed towards the plaintiff's claim. Therefore, the 14-day clock had not started. The student's jury demand was timely. The court must provide a jury trial on the damages claim. Now, Part 8, number of jurors. Now, imagine the trial begins with an 8-person jury. During deliberations, 3 of those jurors become sick and are excused. The remaining 5 jurors return a unanimous verdict for the student. Can the contractor challenge the verdict? And the answer is yes. Rule 48 requires a jury to begin with at least 6 and no more than 12 jurors. A judge may excuse jurors for cause. However, unless the parties agree otherwise, the final verdict must come from at least 6 jurors. The verdict must also be unanimous unless the parties agree to a different requirement. Because the jury dropped below 6 members and the parties never agreed to accept a smaller jury, the 5-person verdict was improper. The contractor could object. Now, Part 9, jury selection. Before trial begins, potential jurors go through a process called voir dire. During voir dire, the court and the parties question jurors to determine whether they can be impartial. Each side receives up to 3 peremptory challenges. A peremptory challenge allows a party to remove a juror without giving a reason. However, those challenges cannot be used to discriminate based on race or sex. A party may also challenge a juror for cause. When a juror is challenged for cause, the judge determines whether that person can remain impartial. Certain relationships create a presumption of bias. For example, a juror owning stock in a corporate defendant, or a juror or spouse previously working for a party. In those situations, the juror may need to be removed for cause. Part 10, objections to jury instructions. Finally, let's discuss jury instructions. Assume the statute only allows compensatory damages. However, the plaintiff requests an instruction allowing punitive damages. The judge tells both parties before closing arguments that the instructions will be given. The defendant says nothing. The jury later awards $1 million in punitive damages. Can the defendant challenge the instruction on appeal? Generally, Rule 51 requires a party to object to a jury instruction when the party first learns about the proposed instruction. If the party fails to object, the issue is usually waived. However, like in law, there's always an exception. A party may raise the issue on appeal if the court committed plain error affecting substantial rights. Here, the defendant failed to object when the judge announced the instruction. Normally, that would have waived the argument, but the instruction directly contradicted the statute. The error was super obvious, and it affected the defendant's substantial rights because it allowed the jury to award damages the plaintiff was not legally entitled to receive. Therefore, the defendant could still challenge the instruction on appeal. Now, here is the Big Law University final review. Remember the big picture. The judge decides law. The jury decides facts. A motion to dismiss asks, even if everything alleged is true, does the plaintiff have a claim? Summary judgment asks, is there enough evidence for a reasonable fact finder to decide this case? Judgments as a matter of law ask, after hearing the evidence, could any reasonable fact finder rule differently? And when it comes to jury trials, legal issues go to the jury. Equitable issues go to the judge. The bar exam loves testing these distinctions because they reveal whether you understand how a courtroom actually works. Master who decides what, and you will recognize these questions much faster on the exam day. This is Big Law University. Know the law, own the room.